Hello friends, in the series on the income tax cases, today we will discuss the case of Naveen Balaji versus Deputy Commissioner of Income Tax. This case has been reported in 460 ITR page number 23 and the matter has been decided by Madras High Court and the date of the judgment is June 30, 2022. This is a case on prohibition of Benami Property Transaction Act. As this act takes the power from the Income Tax Act and during the income tax proceedings, if some Benami transactions are suspected by the department, then the department refers the matter to the initiating officer. Section 24 subsection 1 of the Prohibition Benami Property Transaction Act gives power to the initiating officer that if the initiating officer has material in possession and has reason to believe that the property held by the person is Benami, then he can give a show cause notice to the benamider that why his property should not be treated as Benami. Apart from that, section 24 subsection 3 gives further power to the initiating officer that if the initiating officer during the proceedings feels that the assessee can alienate with the property for which the notice has been sent to the assessee, then in that case the initiating officer has the power to provisionally attach that property for 90 days from the end of the month in which the notice under section 24 subsection 1 has been given, and he can provisionally attach this property with the approval of the approving authority. Now further, section 24 subsection 4 clause A clause I gives the further power to the initiating officer that he can enhance this provisional attachment period up to the order of the adjudicating authority which is passed under section 26 subsection 3, meaning thereby that once the property is provisionally attached and the period of 90 days is expiring, then the initiating officer can extend this provisional attachment till the period the decision is given by the adjudicating authority. In the present case, the provisional attachment period was extended by the initiating officer, so the assessee moved to the Madras High Court about this provisional attachment by taking the plea that the assessee has not been given the opportunity of cross-examine that person on the basis of whom this Benami proceedings have been initiated against the assessee. For this, the Madras High Court said that the principles of natural justice and fair play depends upon the facts and circumstances of the case and they are subjected to the statutory provisions. It was the opinion of the Madras High Court that there is no provision of cross-examination to the assessee at this stage when the matter is pending before the initiating officer. The Madras High Court was of the opinion that if any adverse decision come of the adjudicating authority, then the assessee has every right to go to the appellate tribunal, and if the appellate tribunal gives the negative decision, then the assessee has every right to go to the further courts. So the assessee should not be very cautious and jump to filing the writ petition in these matters, and the assessee has to wait before the initiating officer, before the adjudicating authority and then appellate tribunal. So in the present case, the Madras High Court declined to entertain the writ petition of the assessee against the enhancement of the period of provisional attachment done by the initiating officer. Friends, my point in this case is that this act, that is Prohibition of Benami Property Transaction Act, gives exorbitant power to the initiating officer. As all we know that the process of recording reasons, the process of taking the approvals from the higher authorities, more or less now are for the rituals. They are done and they are usually done without application of mind, whatever the initiating officer or the assessing officer make the proposals, they just act as a rubber stamp in most of the cases, it has been seen. So if this type of exorbitant power will be given to the initiating officers, then this act may be very dangerous for the assessors fighting their cases. But in this case, the Madras High Court declined to entertain the writ petition of the assessee against the enhancement of the period of provisional attachment. At the end of this video, once again, I am repeating the name of the case. The name of the case is Naveen Balaji versus Deputy Commissioner of Income Tax, and this case has been reported in 460 ITR at page number 23. The matter has been decided by Madras High Court and the date of the judgment is 30th June 2022. Thank you, friends.